going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. All right, I've got a weird one, an interesting one, and slightly kind of funny one. This is a Nelson hearing. A Nelson hearing is when the defendant pretty much says their attorney sucks and isn't working for them, so they try to get a different counsel. All right. I also have another note to say. This is a little bit older. Because of all the courts that are closed, I had to jump into the vault. This happened probably about 6 months ago, I think. I don't know the exact date, but it was earlier this year. All right. That being said, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
All right. Miss Wilson, come on up. All right, Miss Wilson. Oh, are you okay?
Yes, ma'am.
Okay. All right. Miss Wilson, if you will, please raise your right hand. Do you solemnly swear or affirm that the testimony that you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Miss Wilson, in communications to me, you had made a request for different counsel. Is that, or requested a Nelson hearing? Is that right? Is that right?
Yes, ma'am.
Okay. And so in order for me to continue with a Nelson hearing, I have to hear that you have an unequivocal request that I consider appointing somebody else to represent you other than Mr. Green because you believe that he has been ineffective in representing you. Is that accurate?
Yes, ma'am.
Okay. And so now I need you to tell me all of the reasons that you believe Mr. Green has been ineffective in representing you. Then I will hear testimony from him. And then I will make a determination. Okay.
Okay, I have a question.
Yes.
Okay, so I have the statement that I would much rather read than this.
Then testify. That's fine. You can read it and I will consider it as testimony.
Okay. It's not good morning, but good afternoon, Your Honor. And I first want to thank you for allowing me the opportunity to speak today. I would like to plead to the mercy of the court and ask for a sentence of 1129 with time served because I am ready to accept full responsibility for my actions. I know that I agreed to take the plea, but that was before Mr. Green went try to kind of plead after the second time of me seeing me before June the 4th on May 31st. And after I saw that I did not score out to go to prison, which is 28 points and could be sentenced to a non-punitive sentence. That's okay, but I apologize to this court as well as my family and my friends for failing it and them. But most of all, I ask for forgiveness from God. I'm sorry.
It's okay. And take your time, and that's okay.
And asking for forgiveness comes accountability. And through my accountability, I have faith that my request will be considered and granted. But I am sure that the will of our Father God will be done today. And I'm ready to receive whatever God has put on your heart for me to receive. Once again, I thank you, and this court for the chance for me to speak.
Okay. Ms. Wilson, you are welcome, and I'm happy to hear from you. Okay. Can we get her? Oh, okay. There's some issues. Ms. Wilson, I did not hear anything in that letter that you heard, that you read about what you think Mr. Green has done wrong in representing you. So is there anything else you want me to consider in this Nelson hearing?
It's just a simple fact, like you can't, if I ask you to counter plea and you tell me that we can try, but that you're not going to, that's a problem for me.
All right. So did you ask Mr. Green to make a counter plea?
Yes, ma'am.
Is that a yes? And did he say, no, I'm not going to?
She said that we can try.
Okay.
But they didn't.
They didn't do the counter plea? Why do you think they didn't?
Because she said it was a minimum mandatory for me for 24 months. It's just a simple fact that, like, if you just do it, like at least let me know that you would try to do it, but you're not gonna do it, that I don't want to accept that.
All right. Mr. Green, what do you know regarding the situation and the plea negotiations with the state?
Judge, we talked to Ms. Wilson and the state had offered 24 months. And it's my recollection that she agreed to that with her time, credit for time, and that she didn't want to plead at that time. She wanted to put it off. And when she came into court and said that she wanted to fire me, I was kind of shocked. I wasn't expecting that because, and I filed a response to the thing. I thought everything was fine until she got in here and said she wanted to fire me. And I didn't know I'd offended her or whatever like that. I certainly didn't mean to. But, I'd be glad to, if it's up to me, and I tell all of them, if it's up to me, I'd turn them all loose. But I know the state won't, and I know that Your Honor won't. And so it's not up to me. And all I can do is communicate to them and then try to work out something that they would rather have. And that's the best I can do. And that's all I could do for her. And I did that.
Okay. Is there anything else, Ms. Wilson, that you want me to consider?
I do apologize for that. I really do. Because I did get you off guard, but like, whenever I left you, because I really wanted to do it the last time we was at court, but the court docket was busy. So that was my mistake.
Okay.
I'm sorry. It's not funny, but I really do apologize for that because I did get you
That's
off
okay.
guard.
That's okay. All right, Ms. Wilson, I have not heard sufficient evidence to lead me to conclude that Mr. Green has been ineffective in representing you, okay? Therefore, I will not remove him as your attorney, but if you tell him that you want to make a counteroffer to the state, he will make that counteroffer. That does not mean that the state will accept it.
I know.
Okay,
I know.
so you indicated when you first started talking to me that you were willing to take a sentence of 11 months, 29 days in county jail. Is that right?
Yes, ma'am.
All right. So is that the counteroffer you wanted Mr. Green to make to the state?
Yes, ma'am. It could even be like just something lower, because like I know I did wrong, and I don't want to get out of nobody's probation.
All right.
And I know I did wrong.
Okay.
So if I had to sit, I know I had to sit. And that'd be perfectly fine with me.
Okay. State, what's your lowest offer thus far?
Judge, just to recap where she is, she's in a unique position. She started out with a PTI. She has really no record at all.
Okay.
And she failed the PTI. She then accepted a plea of 24 months probation on a withhold adjudication for simple possession of cocaine. In June, she fails, she absconds. She gets picked back up, she goes to inpatient drug treatment at Aware. My understanding, she probably completes Aware, but she then absconds again. So I don't believe that she's amenable to probation. Given her record, I will be willing to offer her 11.29 a day at the jail. We'll take her for 11. I have not confirmed with them, but.
How does she do at the jail? Is it a medical issue? Is there a medical concern?
Where?
Why don't you call? And that way
I believe she has 79 days of credit. If the jail is willing to, I will make an offer today. I think she also has a hold for Seminole County.
Yes, I do.
I don't know what she has in Seminole.
What do you have in Seminole County?
DUI.
Oof, that's not good. That's really, really bad. Now that this is not going to resolve your Seminole County situation.
I know. They told me that I would have to come back there anyways.
Yeah, you would. But you're not going to come back until after you're done with
I know.
the sentence.
I know, man. That's why I said I know I'm gonna have to see.
All right, while they're calling the jail, this is yeah, she turned this Nelson hearing into a plea negotiation, which if that was her strategy, it worked.
That's cooking position.
But yeah, she didn't say anything about what the attorney did wrong for her. She just didn't like the offer, which is fine. You don't have to like the offer. You don't have to accept it. But she just admitted guilt, though. So don't know what she's going to do with that.
Any issues?
All right, there's a second hearing after this, a second Nelson hearing. So
Well,
That's-
I'm happy
that's
for you
the-
to
the
approach.
more interesting of the two.
Approach, or tell the state and the defense.
Okay. Your Honor, the best I can do today would be a year and a day. I know that requires her to go be committed, but at the same time,
Fair enough. All right, so Mr. Green, do you want to take some time to talk to your client and I can go forward with my next case? And see if you can resolve the case today?
If that's what you'd like me to do, Your Honor,
Or we can pass it to the next time.
I'd like to pass it.
You would? That's
I'm
fine. I don't have a
2
problem with
hours
that.
late.
Yeah, I understand.
Okay.
Yeah, let's pass it then. Ms. Wilson, so I'm not removing Mr. Green as your attorney, but I will absolutely consider any plea the next time we see each other. I'll have you come back on August. I'm going to have you come back July the 16th in light of the offer that's been made. And in between, is that too soon for you? Between now and then, Mr. Green's going to come see you. Okay, so that's next Tuesday. You have nothing to be sorry about, and he is a professional and he is not upset at you.
I don't get
Okay,
upset.
he's not upset at all. So please know that.
Thank y'all.
Okay, yes, ma'am.
Have a nice day.
Yes, ma'am. You too.
Okay, we need to.
Miss Brown, you with us? I am so very sorry that this docket is going so long.
It's okay, Judge. I'm sitting right here working away. And if I
Okay,
if I
good.
have to listen to
Excellent. I'm
somebody for
getting
a
Miss
couple of hours,
McKenzie up.
you're the perfect person to listen to. Perfect judge. So,
Yeah, I don't know
I
that
don't mind.
listen, I'll share with you what my youngest kid said after he watched the trial. I'm like, hey, do you have any constructive criticism, Chris? He's like, you should just stop talking so much. I'm like, okay, Chris, well, that's all.
Okay.
That's what I had to do.
Yes.
The Supreme Court says because of the jury instructions. He's like, will you just stop talking so much?
I feel like, maybe Chris is someone who often comments in my comment section. If you just stop talking so much, you'd have more subscribers. Yeah, I mean, it might be true for me too.
It's nothing like children to keep you humble, right?
I'm telling you, they do keep us humble, don't they? I got the grandchildren
They sure
working on
do.
me.
Oh, listen. All right. Miss McKenzie, hello.
Hello.
Miss McKenzie, we are here. Give me one sec. In your case number 23 CF 337. Miss McKenzie, if you will, please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. Miss McKenzie, at the last time that we were in court, you made a request for the court to consider making a determination that Miss Brown has been incompetent in representing you and determine that you wish to represent yourself. Is that right?
Well, I don't want to represent myself for sure, but I would like to have a attorney that work for me, will be diligent and competent and respect for me. I
Okay.
do not have the skill to represent myself.
Okay, fair enough. So you do not wish to represent yourself. Is that
Absolutely not.
correct?
No, ma'am.
All right, fair enough. So, Ms. McKenzie, I'm going to proceed with what we call a Nelson hearing, and I'm going to make a determination whether or not I find that Ms. Brown has been ineffective in representing you. And what I need to know from you is what are your complaints? And then I will give Ms. Brown an opportunity to respond. Okay?
Yes, ma'am.
All right, Ms. McKenzie, tell me, what are your concerns with Ms. Brown's representation?
Okay. Well, ma'am, before I became incarcerated with this, where I am now, I had been reaching out to my attorney by emails, even before, actually, let's go back, even before she was legally appointed to me. I've been reaching out
for her. And then after she was appointed to be my counselor, I've been reaching out and then I asked about, I said this, rather than I'm saying which one, I said, I want a speedy trial. In other words, I want the quickest one. Because if I win or lose, I have an opportunity to appeal it. And my case is child interference. Okay, and ma'am, I know that you can't be involved, but I even sent some emails to your assistant, Miss Debbie, saying, can y'all reach my attorney? She's not returning my call. I attached emails to her along with Mr. John Thomasino, the clerk of the Supreme Court, and everybody, like saying, hey, let's get something going. I said, and I told her, I said, it's not even an issue of me saying, okay, give me a plea, because before I got in this situation here, it was a plea bargain of 6 months community control to run with my probation in Washington County. I turned that down. Not saying that I will win or lose a jury trial, but the case of child interference is way bigger than me at this point. We're not going to, and I explained these things to my lawyer at the time. I said, listen, my baby got put in human trafficking in a group home at 16 years old. Now, and another thing, I mentioned to her on the discovery, it was people named that should have been there. Rachel Brooks, she's a human trafficking fighter of the and her husband's a CIA agent. They paid for those motel rooms. And the discovery that she gave me did not have those people's name on it. And the thing about it is, I feel at this point, when you tell your lawyer, even if I may not be the brightest cookie in the apple, hey, you can verify that. And currently, I also inform my lawyer of the current civil matters, which is right now that's in the 11th Circuit. It got those parties on it. And that number is 24-01899.
Hold on, Ms. McKenzie. You are concerned that you reached out to her via
Yes.
email and she did not respond
Yes,
timely.
and phone calls and text messages.
Okay, well, so is it emails or
All of it.
all of it? And phone calls and text messages? Help me understand, why were you communicating with her before I appointed her to represent you?
Because I was trying to, originally, my daughter, India, we got to go there. She had went to jail in Washington County for some charges, and I was going to get her to represent India, which is a victim in my child interference.
Let me be clear. I am not going to consider anything that you have concerns about
Yes, ma'am.
before I appointed Ms.
Oh,
Brown
yes,
to
ma'am. Okay.
represent you,
Yes, ma'am.
because that has nothing to do with
Yes,
this
ma'am.
court's appointment.
Yes, ma'am.
Okay,
Yes, ma'am.
but you also indicated that she's done something wrong with regard to discovery. Help me understand your complaint
No,
there.
ma'am, not that she done anything wrong. It wasn't addressed. The discovery that Mr. Lawrence Gill said presented,
Uh-huh.
the names on there had every name other than Rachel Brooks, which was a lady that were.
Help me understand. Why is that Ms. Brown's problem? Why do you
Because she's
think
my
that's
lawyer.
something she's done wrong?
No, ma'am, I'm saying I wrote her about her to contact Mr. Gibbs. I can't contact him because I have a lawyer. He's not going to respond.
Are you telling me you want her to disclose Rachel as a witness?
Yes, ma'am, and correct the discovery that he gave her. See, I can write you all out.
Let me say this. Ms. Brown doesn't correct Mr. Gill's discovery.
Okay.
Mr. Gill gives whatever discovery he wants.
Well, yes,
I mean,
ma'am.
he could name the president of the United States. Ms.
Yes,
Brown can't change that.
Yes, ma'am.
Okay. Ms. Brown can say, Mr. Gill, I'm going to give you certain names of people
Okay.
that have information. And then she does that. Is that what you're telling me
Yes,
you wanted
ma'am.
her to do?
Yes, ma'am. That's what I was trying
Okay,
to do.
you
I
wanted
just didn't know
her
how
to
to do it.
disclose certain witnesses.
Yes, ma'am.
Okay. And then what are your other concerns with her representing you?
Okay, the lack of communication. I
All right,
mean.
you've told me about
Yes,
that.
ma'am, I understand you got millions of clients and you can't talk to me 30 minutes out of your day. I own that. But at the same time, this case has been going on over a year now. And I'm saying in front of, and I want the quickest way ever of a speedy trial. Quickest. If it's demand, I may be saying whichever one is the quickest. Whichever way that we can get it going. Because without a reasonable doubt, and that's all I want. I mean, and Ms. Brown came to the jail recently. She spoke to me.
Sure, but let me say this. She was only appointed as your attorney in February. So it's only been 5 months that she's been in as your attorney. Is
Yes, ma'am.
would you agree?
Yes, ma'am.
Okay. All right. Fair enough. So I know your case has been pending. Excuse me, but she has not been your attorney that whole time.
Yes, ma'am.
There has been conflicts,
Yes, ma'am.
right?
Yes, ma'am.
There was a capious. The KPS didn't get executed until November of 2023. You went out on surety. You came up for a hearing with Ms. Simpson. She conflicted off your case. Then you got Office of Regional Conflict Counsel. Then they conflicted off your case, and now it's Ms. Brown. So your main concerns are that Ms. Brown has not disclosed certain people in discovery, that she has not asked for a speedy trial, and that she has not communicated effectively with you. Do you have any other concerns?
No, ma'am, that, you said it all.
Okay, Ms. Brown, if you will.
All right. Do not worry. I am not going to skip right past the fact that she said, I am not the brightest cookie in the apple. Now, if that's an actual saying, I've never heard it before. I'm going to go ahead and say she mixed two, what are those, analogies? They're not analogies, whatever they're called. Yeah, she, okay, let's go. I told you, it's weird, interesting, and then gets kind of silly.
To the extent that you are able, disclosing the minimum amount of attorney-client privilege, can you tell me your responses to those three concerns?
Yes, Your Honor. Good afternoon. Good afternoon, Ms. McKenzie. I'm surprised that we're going forward with this because I thought I've had an in-person visit with Ms. McKenzie since she filed for the Nelson hearing. Now, it wasn't because of that, but it was because I was able to actually visit Ms. McKenzie and someone else in one of the outer counties in person, which is what I prefer. And Judge, Ms. McKenzie has communicated with me. It's impossible to keep up to count the number of times. I do have a record of text messages. There was one day that Ms. McKenzie called me and I had her on the phone for over an hour and a half. I just put the phone down and continued to work and try to listen at the same time. Ms. McKenzie was insistent and persistent in calling constantly, and she would call from different numbers. And sometimes I would talk, but most times I would say, especially after maybe the initial 5 or 6 times, I said, Ms. McKenzie, I don't have time to do this. I have other cases. And so, but since that time, Judge, I have been active on Ms. McKenzie's case. I've actually reached out to Mr. Gill. This was on July 1st. I reached out to Mr. Gill. Actually, I called him, I think it was on Monday of this week, but he might have been in court or something, but I talked to his assistant, trying to see what kind of plea offer we could work out. Because when I talked to Ms. McKenzie, she was very concerned about her Washington County cases, in which I reached out to Ms. Ford, who's the assistant state attorney on those cases. And I sent an email out to both of them because it's my understanding that Ms. McKenzie is very wanting to resolve Jackson so she can get over to Washington. And so the email that I sent out was trying to see what we can do about a global resolution. And so I'm not 100% sure how to respond, except to say this, Judge. Ms. McKenzie is probably as bright as she is persistent. And she is very knowledgeable of what her circumstances, and there's so it's a myriad of things that is overwhelming because she has a difficulty in staying on one point, and so she kind of loses me, and I have to tell her just kind of slow her down and everything else. So it's kind of hard to keep up with her. Of course, I don't do speedy trial, motions for speedy trial until and if I'm ready, based on all of the information, all of the discovery, before I would dare to file something like that, because that's more about me asserting that the child is ready to go forward than her, and putting my name and reputation on the line. And also, a lot of time when she was asking, I hadn't even gotten discovery yet. So as it is now, Judge, I do have a communication open with Mr. Gill, trying to see what we can do to resolve this case. And like I said, we had a good visit when I was there. As a matter of fact, they were kind enough to let me come in, and I didn't even have any ID. I don't know how I left without any ID, but they believed me. And so we had a good visit, and we talked, and I thought the matter was resolved. But that's all I have, Judge.
Okay. All right. Ms. McKenzie, anything else that you want me to consider?
No, ma'am. I think that's.
I'm sorry, Judge. One more thing. I apologize. No,
Go ahead.
I
Go ahead.
apologize. Miss McKenzie just called me a day or so ago, and we talked. And I think it was there, so it might have been this week, but we talked, and she asked about what was going on, and I told her what I'm telling the court now as far as what I have in play. I told her about the cases that are in Washington County, and some of them are a couple of VOPs and a new law too. I'm looking at the email, and told her what I was trying to do, in effect, which was what I thought she wanted, and she seemed satisfied. It was probably the shorter of the phone calls that we've ever had, because she seemed to be okay with it.
All right. All right, Ms. McKenzie, I have heard what you have to say. I have heard what Ms. Brown has to say. And I do not find that Ms. Brown has been ineffective in representing you. And so I'm not going to fire her and put somebody else in. But I will consider allowing you to represent yourself if you wish. Or if you wish for Ms. Brown to stay on, it sounds like she's on it and she's working on trying to get your cases resolved. So what do you want to do?
Ma'am, would I have a backup counsel since I don't have a?
No, you've got one counsel. Her name is Sydney Brown.
Well, can I say this on record?
Yeah, you may.
I'm saying this on record. All right, Ms. Brown, thank you for coming to reach me, but it has been 2 bar complaints as well. Okay, I don't know if that make it matter, and now that I'm saying.
I don't know what that means. What
I sent you a copy of the bar complaint. that
I
was
don't
sent.
read what you send me
Okay,
unless you do it in print. Listen, and I cannot see anything from anybody
Yes, ma'am. Well,
one-sided.
yes,
So
ma'am.
you have filed 2 bar complaints
Yes,
against
ma'am.
Ms. Brown?
Yes, ma'am. Now,
Okay,
that was before we had this hearing.
sure.
So,
Ms. Brown, does that now
It was
make it
before
so
we had the
that
hearing.
you have concerns about proceeding?
Not at all, Your Honor. I was not aware of the
Okay.
bar complaints. I guess there might be sitting in my PO box, but it doesn't change anything, Your Honor. I fully intend, if the court
Thank you.
keeps me appointed, I fully intend to represent Ms. McKenzie with the professionalism and zealously as I can, and I would for any other client of mine, Judge.
All right, fair enough.
I
Is
just
there
wanted to
anything
say
else
that
that
now,
you
that
needed
way
to
it's all out
address?
there.
Sure.
Yes,
Is there
ma'am. Thank
anything
you.
else you need?
No, ma'am. Thank you, Judge Garcia,
right.
for having this hearing.
Ms. Brown, when would you like to come back on this case? You may.
I know that we're here just for a Nelson hearing, but
Yeah.
I think that I've spoken to Ms. Ford. I have not discussed this with Ms. Brown yet, but what I would like, the state would be requesting to have Ms. McKenzie sent to Washington County with the hold for Jackson. I've spoken to Ms. Ford. Ms. Ford is well aware of her charges over there. That will be driving the boat. I think that she'd be better off over in Washington County with those charges. Ms. Ford is going to resolve my case with with her Washington County charge. I know that.
Well, let me ask, why is she here? I don't see a hold without bond or KPS or Jeannie. Am I missing something? Why is she here?
Your Honor, I checked on that. I'm sorry.
No, go ahead, Ms. Brown. I'd love any
Yes,
input.
Your Honor, I checked on that because it's my understanding that the reason she is there is because of the hold in Washington. And Washington,
Yeah, but
I have
why
case
isn't she
numbers,
in Washington jail?
but she said the warrant hasn't been served. So that's why there's the hold there, and they won't serve the warrant. So and
All right,
then I
versus
couldn't even
the jail's
access the
gonna go
cases
find out.
because of the warrant.
Yeah, I don't understand why she's here because I'm not seeing on our case that she's in custody for anything other than, I mean, arguably
And I think she was on bond, out on bond for that. But and so that's what I was kind of wanting to go up in arms about, to see why she's on hold in Jackson County, why she's in jail instead of
Jeannie-
out.
Jeannie's trying to, hold on, Ms. Brown, I'll let you know what Jeannie's saying. What are you saying, Jeannie? Because she can't hear you.
In this case, she was originally picked up on our warrant in Washington County
Warrant for what?
for the original, when it first started.
Yeah, but she's been out for a while because she can't.
Security bond, but
Yeah.
I don't have any information as to why she's in the jail now.
Ma'am, I wrote the inspector, I'm sorry, can I speak, please?
Yeah.
I wrote the Inspector General of Department of Corrections. And I gave Ms. Brown.
Do you
the
know
letter.
why you're in Jackson
They
County?
said pending charges for Washington County. Yeah, on Ms. Brown, you have the letter from the Inspector General. Oh,
I
no,
do.
no, ma'am, no, sir. It says pending charges and the violations.
Then why
are
wouldn't
pending.
they, why didn't y'all just send her to Washington?
Exactly.
When who brought her? Washington? Washington brought her here?
No, ma'am. Jackson, I'm
Were
sorry.
you in, did you get put in jail in Washington County and
In
then?
Jackson County on a Washington County hold. I was at the dollar store. The officer said, we just got a call that a woman with the CAPIS for Washington County is here. May I see your ID? I say, sir, here go my debit card. I'm Tabitha McKenzie. And he said, oh, you have a hold for Washington County. I'm gonna take you to Jackson County. Then when I went to first appearance for Jackson County, Judge Taylor said, well, only thing I see right now is a hold for Washington County. I'm gonna get them expedited. We don't have anything else, and I've been here since April 20th. Then I gave Ms. Brown the letter from the Inspector General saying, hey, your charges are pending in Washington County. So if you're not pending, let me free.
So Washington, and there's been no expedition here, I imagine. Or I don't know if it's needed for another county, but
Why
Washington
hasn't
County
Washington
apparently
ever
has
come
not come
together?
together, and they need to.
I wrote even about the 40-day.
We're gonna send you to Washington County. It probably won't be today. It probably.
All right, I'm going to say this. If there was ever a reason to get a Nelson hearing, accepted or passed or granted, it'd be this. The attorney doesn't really understand what's going on. The judge doesn't understand what's going on. The attorney should be the one that steps in and says, this is exactly what's going on. Now, she has a little bit of information, but she doesn't have the whole picture. They do figure it out, what's going on, and it seems a little weird, but it is what it is. All right, let's finish this one up.
Will be tomorrow morning, but we're going to go ahead and get you to Washington County, and we will show that. When did you get put in custody?
The 20th of April.
Is that the 20th of April? All right, the court is going to show, why wouldn't this show served her Washington County warrant? But I guess if we took her into custody and she didn't have Jackson charges that she was in jail for, why didn't she just go to Washington?
Without having her file here.
Without having her file. Do you think we need to just bring her first appearance
Yes, please.
with Judge Mercer? And that way there can be some sort of indicator. Ms. McKenzie, I want to make sure that you get credit for the fact that you've been in jail in Jackson County since April 20th
Yes.
for Washington County, because you are not in jail in Jackson County for Jackson County
Ma'am,
case.
and I did express that to Lieutenant Williams at the jail, because whenever judge, that yellow paper, they say you got 21 days or 40 days, just tell me why I'm charged. I wrote them, I said, okay, at least if I'm held for Washington County or whatever, why am I held? And I gave Ms. Brown the paper. If they say a new violation, then what is the charge? I spoke to Kayla Corbett with the courthouse, and that's the thing. It wasn't you. You didn't revoke any bond or anything.
Now, I will say this, it is possible that because your Washington County case happened after this one, that they're saying it's a violation of your current bond, but there has been no revocation. The first appearances, for whatever reason, are no longer showing up in videos anymore, which is really difficult for me.
Yes, ma'am.
I've got no record of the first appearance. I'm gonna just have you come up before Judge Mercer, but more than anything, I want to make sure we let Washington County know that she's held here on their bond
Yes.
in case number 24 CF 146, so that we can figure it out.
Would Judge Mercer be able to do arraignment tomorrow?
No,
No. only
not on the
County?
Washington. Oh, you got to go to Washington.
Okay, no problem. Okay, thank
And
you.
Judge, they
Yeah.
also,
Thank you, Ms. Brown.
and Your Honor, they
Yes,
also
ma'am.
have her, Washington County also has VOPs based on 24 CF 146 and 22 CF 107 and 23 CF 160. All those two VOPs are also Washington County.
Okay. All right.
All right, thank you.
Fair enough. We'll bring you back up tomorrow morning and then we'll make sure you get to Washington County, okay? All right. Thank you. Ms. Brown, anything else? Don't leave. Let me just ask your attorney. Anything else, Ms. Brown?
Nothing else, Your Honor. What time is first appearance, Your Honor?
First appearance will be at, no, is Mercer back tomorrow? Does anyone know? Okay, then it will be at 8:30
8:30.
Central Time.
Yes. And would it be your Zoom information, Your Honor, or someone else?
No, it'll be something different. What do we know more? Hold on, I got more information from Gross. What do we got?
Okay, so apparently she's had some issues in Washington County with some of the.
Okay.
some have basically been housing her.
Ms. McKenzie is being housed in Jackson County for Washington County at
Okay.
Washington County's request because she has had issues with the staff at Washington County, but the problem is they didn't show their warrant as executed.
That's correct.
So it doesn't sound we need to bring her up in first appearance. It sounds like I just need to get with Judge Register, make sure the state needs to work on it. I will work on it from the judge's standpoint. Make sure that it shows that she is executed and that she's here on Washington County charges and they need to move forward with their case.
Okay.
Megan Ford is aware of Ms. McKenzie. I've spoken to her about it, but she said that she needs her over there. No, I mean, not physically, but she wants.
Tell Megan what's the deal is, that basically we're housing her for them and that to go ahead and start transporting her to court. And we'll,
Do that. I'm just.
so basically what's happening is you're being held in Jackson for Washington.
Okay.
But your time should have been running all this time and there
Yes, ma'am.
shouldn't be a pending warrant.
Yes, ma'am. So that means Jackson will have to execute that warrant if I'm gonna be housed there.
Well, Washington will do that. I'll make sure they do that.
Thank you.
Yep.
Thank you very much. And thank you, Ms. Brown, and thank you,
You're
Mr.
welcome,
Gills.
Mrs. Smith.
Thank you.
You're welcome. You're welcome. Thank you, Your Honor, for getting to the bottom of it. And
Yeah, no
I'm
problem.
going to follow up with Ms. Ford as well.
So yeah, she is not going to first appearance tomorrow because now we got to the bottom of it. Okay.
Yes, Your Honor.
All right. Excellent. Well, then that should conclude court for today. Oh, you've got.
All right. That is it. Thank you guys so much for hanging out with me. This was a little bit longer of a video, which is why I made it a premiere. Yeah, that second one was interesting. The defendant filed bar complaints against the attorney. I mean, that's a little extreme. Hopefully they just kind of get, read, filed. It's like, yeah, there's no merit to these. Hopefully. It doesn't sound like she's misrepresenting her, and a bar complaint is a little extreme, at least in my opinion, unless there's something egregious. All right, you guys are awesome. If you don't mind, please hit that like button. I would very much appreciate it. If you didn't like it, feel free to hit the dislike button. They actually both help. Anyways, until next time, bye.